Yes.
So let me leave court so that we can allow them to exit.
Okay.
Mr. Wanyam?
No, you want to be actually exiting so that we leave room for you.
Wasimamisha ukuru doctor.
So this is my ruling on the bail. 19 accused persons have been presented to this court and taken plea of various charges. They appear variously and in subsets in the total of 27 charges presented before court today. This ruling is chiefly on the application for bail. At the onset, it's necessary to state that the state does not oppose bail. The plea to this court is that it takes into consideration the nature of the charges each of the accused has pleaded to. As an additional check to the right and the sanctity of trial, the state also argues that the accused persons and the legal representative are to observe the sub judice rules strictly. The state also seeks that they be a countermand against the accused's interference with the witnesses. In their response, the defense has reiterated that bail is a constitutional right. They went to great lengths to show that the charges were not as serious as are in many similar matters. They pointed out further that all the charges, the accused persons did not have direct dealing with the county government, as they were subcontractees in the tenders or bids forming the basis of these charges. In buttressing their plea for reasonable bail, they stated that they had cooperated with investigative agencies, and further that they state that they will comply with the court's direction and are willing to deposit their passports in court and limit their movements out of court's jurisdiction. It was also their statement that they would comply strictly with the sub judice rule. They urged the state to also favor that rule in this matter. The defense further pleaded that with the court to take into consideration that one of the accused persons is a person living with disability and also is of fragile health. Further, that court should note that most of them are from the same extended family, and therefore terms of bail should be such as not to strain the family resources exceedingly. They ventured to suggest that a cash bail of 50,000 would be reasonable and should be the upper limit. The defense reiterated that each of the accused persons should be individually considered in terms of their unique circumstances and involvement in the matter. It is necessary to state that the 19 accused persons, of the 19 accused persons charged, only the first 11 accused are natural persons. Accused 12 to 19 are all inclusive are juristic persons. Bail being unopposed, the only issue for the court to determine is what is reasonable bail in the circumstances of each accused vis-a-vis the demands of the law. Section 123A of the Criminal Procedure Code provides 4 statutory provisions in reaching a decision of bail and bond. 1, the nature and seriousness of the offense. 2, the character, antecedents, association, and community ties of the accused persons. 3, past records and fulfillment of the obligations under previous grants of bail. And 4, the strength of the evidence of commission of offense against the accused. In determining the bail bond terms, the court will take into consideration only 3 of these listed above, as I have no information brought to court on the third lien as listed above, which is the past records and fulfillment of the obligations under previous grants of bail. I will also take note of the charges each of the accused is individually facing. The second limb of those considerations, the community ties of the accuseds. It is not an issue that all the 11 accused persons are well rooted in their communities, with family ties and otherwise engaged in meaningful economic activities. This link is favorable to all the accused persons equally. The differential will be the number and seriousness of the counts each of the accused have been charged with. And I will start with the fourth accused, who has been charged with only 4 counts. His terms of bail are set as follows: a bond of 5 million, in the alternative, a cash bail of 1.5 million shillings. Accused 6 and 7 will also be bonded in the same terms, a bond of 5 million, in the alternative, a cash bail of 1.5 million. Accused 2 and 3 will have a bond of 1 million, in the alternative, a cash bail of 400,000 shillings each. Accused 5 will have his bond term set as for accused 2 and 3, which is a bond of 1 million, in the alternative, a cash bail of 400,000 shillings. Accused Accused 8, his bond terms will be set at 8 million shillings, in the alternative, a cash bail of 2 million. The fourth accused, who faces 16 counts, a bond of 10 million, in the alternative, a cash bail of 2.5 million. Accused 9, 10, and 11, a bond of 1 million shillings each, in the alternative, a cash bail of 250,000 each. I have noted that the first accused is the one I write as the fourth accused. The first accused terms of bond are as follows: a bond of 5 million, in the alternative, a cash bail of 1.5 million. And for accused 4, a bond of 10 million, in the alternative, a cash bail of 2.5 million. Please let me confirm that we are all clear on the terms we have set for each of the accused. Defense counsel, any clarification needed?
Your Honor, I think there was a mix-up. If you don't mind, if you can repeat, we would be appreciated.
Oh. So the first accused is Wangamati, and his terms of bond are a bond of 5 million, in the alternative, a cash bail of 1.5 million. These terms also apply to the accused number 6 and 7. Are we clear?
Yes.
Okay. So then we have the second and third accused, and their bonds have been set at 1 million, and in the alternative, a cash bail of 400,000 each. These terms also apply to the fifth accused. The fourth accused is a bond of 10 million, in the alternative, a cash bail of 2.5 million. The eighth accused is a bond of 8 million, in the alternative, a cash bail of 2 million. And then we have accused 9, 10, and 11 banded together, each of them a bond of 1 million, in the alternative, a cash bail of 250. Now we are clear?
Yes.
Okay. So these are the further terms of my ruling. Each accused person with an issued with a passport is to deposit it in court within 7 days. None of the parties are to leave the court's jurisdiction without the leave of court. All parties shall observe, or in the alternative, not offend the sub judice rule. This rule also applies to all court officers, advocates and court officers. The accused persons are neither to contact nor interfere with any of the witnesses by themselves or through their agents. Breaches in any of these terms set may attract legal consequences which are not limited to cancellation of bail. Further, prosecution will provide all documents to be relied on in the matter, as well as provide witness statements. The court vested on the matter shall give further directions on pre-trial. This matter will be allocated to Court 2 for further hearing. Further directions and hearing. So we'll have a mention in 14 days. Is the 17th of September. Any objections to our mention on 17th of October? Sorry, September?
Take the date 17th.
Oh, so you'll be appearing before court number 2.
No, sorry, 17th is not convenient for you.
Maybe the day after?
Yes, 18th is okay.
Oh. Which day of the week is 18th? Thursday. So we have changed the date to the 18th of September. Anybody who wants any clarification? I'm done with the matter. I want to close the file and do something else. Are you the same council that's having the other matter? The other
Yes.
CBSA. So let me leave court so that we can allow this one to be later.
Okay.
Mr. Wanyama?
No, you want to be actually exiting so that
Oh,
we leave room for you.
Wasimamisha ukuru kabisa.
We ask you to take that into consideration. The critical thing is that we don't want the accused persons to appear like they're already convicted at the point of cash bail. We ask you to exercise your discretion in a manner that will ensure that they can attend court and that we've already submitted. They're also not like this. I think that will be the only other addition to our application for bail. That's what we want.
Yes, Your Honor, in the interest of time, I wish to adopt the applications and submissions that have been made by Mr. Olvila and Mr. Onyama to apply to the clients that I represent. That's the 9th, 10th, 11th, and... Yes, sorry, Your Honor, I was saying that in the interest of time, I'll be adopting the applications as well as submissions that have been made by my colleagues, Mr. Onyama and Mr. Wangila, to apply to the clients that are sent. That is the 9th, 10th, and 11th accused persons. suffice it to add, Your Honor, that urging you, Your Honor, to consider and apply the principle of proportionality in the sense, Your Honor, that my clients are facing a single charge, one charge. Your Honor, these are small traders and peasant farmers from Bungoma who unfortunately find themselves entangled in this process. You know, my clients have been extremely cooperative with the ESCC. When they were informed, you know, these are people who are not even on social media. When the ESCC made an announcement that they appeared before the head office at the Interpretation Center, I reached out to them and asked them if they are aware of that they are required. And based on that information, you know, they boarded the next bus from Bungoma, Nairobi, to ACC, where they recorded their statements and the fingerprints taken. Your Honor, the charge they face, they have not been told that they received any money, any proceeds of crime. They have not been charged with receiving any taxpayers' funds. They have only been charged, which will discount at the right time, that they presented documents which were found not to be genuine when they were seeking a tender, which tender was not even awarded to the company which they sharehold. Your Honor, I'll be urging you that you release them on very reasonable terms, in terms of cash pay. Mr. Wangila had proposed a sum of 50,000 shillings to the clients. Your Honor, I've been proposing a sum of 20,000 shillings to my clients. The 11th accused person, Mr. Joseph Wanyonyi, is fairly elderly. I believe he's perhaps the most advanced in terms of age as compared to the rest. He's a presiding clerk of a local church that I attend in Kibilini. Matili Friends Monthly Church. And given that, Your Honor, we undertake that they will not reach out and interfere with any witness. None of the accused persons that I represent holds a Kenyan passport, or any passport for that matter. That demonstrates the peasantry nature of their livelihood. That's all, Your Honor.
Your Honor, if I may. Your Honor, Your Honor, in appreciation of the submission from my seniors, wish to mention that we found that this person will give assurance that they will be able to comply, submit to the directions of reasonable court. And finally, Your Honor, I also want to add a voice that in your decision, we pray that you become very lenient, Your Honor, in the instant case, so that whenever bail is granted, Your Honor does not defeat the purpose of the
accused persons being released. Thank you very much.
That is all for the
Yeah,
defense.
perhaps before my colleague sits, because of the
Yes.
distance, there is an issue that has been raised out. My name is Wangila. I'm Wangila B. He's Wangila A. You can use that.
No,
I'm Eugene Wangila.
Eugene one.
Yes.
Oh, what do you call?
Yes, Your Honor, two of the accused persons, that is 5th and 6th, in line with what my senior Mr. Wanyama submitted, and due to the fact that when considering board, you also look at the strength of the prosecution's case, and the fact that we've been willing to give information, they had actually, at the time of tendering, they had officially resigned from these companies. That is 5th and 6th. And Your Honor, the 5th accused person stays in Mumbai. Just to bolster what my colleagues had said, they are family people. All of them are married, they are breadwinners. Going by even what my senior submitted, we'd hope that you consider that. The 6th accused person, 5th, has just gotten a new job, and traveling from Mombasa to this place and back would be very expensive for her. So in setting the bond terms, in line with what my senior Mr. Wangila said, we really hope that you consider a cash bail of 50,000. Since most of them in due course will prove that they were not even in that tendering process. And that is information we were willing to give the DPP through the EACC, but those are things that will come out as to why the information is not forthcoming.
Anybody else?
No, I think that is all for, unless my colleague who wants to come on record.
Yes, Your Honor, my name is Wati, David Wati. I'm sorry, when my colleague was introducing counsels, I was still on the way. Your Honor, I've been asked to appear for Mr. Joseph Wanyonyi, along with my senior, Mr. Haemba, the 11th accused. Your Honor, in addition to what they have said, Your Honor, I'm aware of the judicial policy on bail, which is well captured. Your Honor, the 11th accused are charged along with the 9th and 10th in charge number 27. To give very, very reasonable terms of bail so that we can take up the issues and raise the necessary objections in the charge sheet first. It is just not desirable to have 27 counts in one charge sheet. The principle of Republic as Mackenzie is there, and section 134. Your Honor, that is all.
Mr. Wanyama, now you are truly done.
Yes, Your Honor, we are truly, truly done.
Mr. Musa, you want to return?
Yes, just a brief rejoinder. Your Honor, we reiterate our position that as you set out the goal term, please take into account the names of tenants. That each of the accused persons in this case. Yes. My learned friend Wanyama did raise a point that the conditions such as not commenting matters also apply to us. That's okay. We have no problem. also did good trial disclosure, you may realize that there are more than 2 councils appearing in the matter.
Yes.
So, in that context, we'll be requesting to know who the lead counsel is. Why? This is very important. Service of documents will be effected only upon the lead counsel. So it is important for my land officials to identify the lead counsel so that for every accused person in the matter we know who to serve the documents. We do not want a scenario where all counsel appearing before they need to be requesting for service. That will be possible. And so the prosecution team is also equally thank you.
Your Honor, there are only 2 sets of counsels for the accused persons. We do appear for the first, second, third, fourth, fifth, sixth, seventh, eighth, and 12th accused persons. 13th, 14th, 15th, 16th, 17th, 18th, and 19th. So, any documents, material that the prosecution would wish to rely in prosecuting their cases against these accused persons, we have already initiated correspondence and this out to the firm of Anyama Manyonge. And in respect of 9, 10, and 11 accused persons, any material that the prosecution would want to rely on can be served to the firm of Aemba, Counsel Aemba, Brian, who is also present in court. So I think I hope that makes it easy and clear for them.
Your Honor, just for seamless representation, so that there is no problem, we also as counsels undertake that if there is change of counsel, then the council will not hold lien on the documents which have been submitted by the state, so that you delay the anti-corruption trial. That is usually a requirement. We just want to assure Mr. Monda that we are really in for a good trial.
Thank you for that clarification, but I think that's a matter that should leave the trial for the time counsel. Because some courts will prefer the parties to serve in person, some courts might counsels collecting documents. So at the opportune time, I've taken note of what you stated. The first thing is to start is to be led by Mr. Wangamati and Manyonge, and the second thing is lead counsel is Mr. Brian Aemba. So for now, allow me some 30 minutes to keep a ruling on this matter. I'll give you a time to return because I have another thing to take. So let us return at 11:30.
We are more glad you are.
Anachoma unga. Wewe chakula cha hali ziko lakini si waachana na maneno bwana.